Well, hi everyone. Welcome along to this webinar today from Digital Team. Today's webinar is really designed to help understand the legal risks with the do-it-yourself approach to offshoring. For those that don't know me, my name is Peter Ward. I'm the founder and managing director of Digital Team. We help organisations solve the biggest challenge that they have today, and that's being able to find the right skills at the right price. We do that by designing offshore teams in Sri Lanka based on your specific requirements. We know that in the market today that finding talent is often like trying to find rocking horse poo. It simply just doesn't exist. We also know that when you are able to find those skills and experience, that you often need to donate a kidney in order to be able to afford them. That's where Digital Team can come in and help you solve that challenge. Offshoring is becoming more and more popular for organisations throughout Australia and throughout the rest of the world. In Australia today, 59% of organisations are outsourcing or offshoring some form of business process today. And with remote work really becoming the new norm, offshoring talent has never been more accessible or more attractive. Organisations are drawn to the cost savings, but also the ability to access a global talent pool of skilled workers. However, there's been a recent legal change in Australia that's really made it very unclear about how you hire the right skills without potentially having a whole heap of risk. There's a recent landmark case that the Fair Work Tribunal has brought forward that's highlighted this risk around offshore workers, that even if they are offshore and even if they're labelled as contractors, they might be entitled protection under the Fair Work Act. As a business, misclassifying or misunderstanding your legal obligations can often cause potential costly disputes, compliance breaches, and also reputational damages. In this webinar, we'll explore the legal risks of offshoring, the implications that you have and the things you need to think about in your business, but also the practical steps that you need to take in order to make sure that you're compliant, especially in this fast changing environment with new legislation coming through constantly. So whether you're directly hiring today offshore, whether you're using a third-party provider, this session is really designed to help you navigate the legal landscape and, more importantly, help safeguard your business. To help us navigate what this recent Fair Work change means, we're joined by Annie Smitten. Annie is a partner at Cooper Grace Ward and specialises in workplace relations and safety, as well as disputes from an employer perspective. She's been awarded in the Doyle's Guide for a number of years as being one of the leading Queensland lawyers in employment law, and also been awarded the best lawyer in Australia in labour and employment from 20 to 23 as well. So Annie, over to you to provide us some insight about what organisations should be thinking about as a result of this recent Fair Work case.
Thank you. Thanks, Peter. Hi, everyone. Thanks for joining. Look, today I'd like to talk about the risks associated with Australian companies using offshore workers, so engaging them directly or either as an employee or often as a contractor, rather than using an interposed entity like an overseas entity that will actually get the team set up for you, and then you have a services agreement with them. So in terms of the doing it yourself, as Peter said, there are quite a few risks associated. The main things that are coming through, and I will talk about the Dijital group decision, which is the decision Peter referred to. The two main issues is whether the overseas worker you're engaging is, if you're saying they're an independent contractor, are they actually really an independent contractor or are they an employee? And that assessment will be made based on Australian law. And the second question is whether, even though you've employed this person and they live, for example, and the case I'll talk about was in the Philippines, and they're performing their work in the Philippines, whether you're still caught under the Fair Work Act, because there is an exemption in terms of engaging overseas workers. They have to be engaged outside of Australia, and the engagement is to perform duties outside of Australia. Now that might sound very simple, but it's actually quite technical. And certainly in the Dijital group is a great example of where Dijital Group, an Australian company, thought they'd engaged an offshore worker in the Philippines. as an independent contractor to provide paralegal services to an Australian business, and they thought they were okay, and it was found that that was not the case at all. But let me just go through it with you, and I'll talk about the facts. So Dijital Group engaged Miss Pascu to work as a legal assistant for a related entity in Queensland, a specialist credit repair firm, and Miss Pascu lived and performed all the work at her home in the Philippines via her own computer. There was evidence of an independent contractor agreement which contained the terms of the contractor under which this worker performed work. So there'd been the exchange of an independent contractor agreement. There was also an extra to the independent contractor agreement where there was an employee non-disclosure agreement, which this person had entered into as well. So Ms. Pascu performed paralegal work, so not as a lawyer, but as a so semi-skilled type work. She was allocated files by email each day and was required to liaise via telephone or email with the clients, banks and other credit agencies on behalf of the clients. And she was paid a flat rate of $18 an hour, which is obviously well below what would be in the Legal Services Award, which would apply to someone like her. So the Australian entity terminated Ms. Pascu's employment, and she alleged that she was an employee and made an application to the Fair Work Commission for unfair dismissal, alleging she was an employee. Dijital Group, the Australian employer, said no, she was an independent contractor. So at first instance, the Fair Work Commission said, well, on balance, she is an employee. What they said was some of the terms and obligations in the contract were real indicia that she was an employee rather than an independent contractor. She used the phone account of the Australian business and identified herself as being part of the Australian business when she took calls. She used a signature block on her emails, identifying herself as being part of the Australian business called MyCry Office. She had a very low rate of remuneration. The nature of her work being paralegal work and not involving a profession, trade or distinct calling. So it was fairly sort of low level, semi-professional type work. She took instructions as to how she was to perform the work and was supervised in performing the work. So that's a really big important issue about control. The arrangement was ongoing unless it was terminated in accordance with the terms of the contract. Importantly, what the Commission said was that the agreement to work as an independent contractor represented no more than a label and was not determinative of the actual legal relationship. So even though in the independent contractor agreement it said that Ms. Pascu had to pay her own tax, she didn't receive any employment entitlements, and she was liable for anything that went awry in terms of performance of her work, they still found that she was not an independent contractor and she was entitled to unfair dismissal, and she was awarded, reinstatement wasn't considered practical, so she was awarded, I think, around $10,000. Now, that doesn't sound a lot in itself, and I'll talk about the appeal decision, but just on its face, if she's been determined to be an employee employed under the jurisdiction of the Fair Work Act, this is more than just an unfair dismissal risk. There's risks already of underpayment. As I pointed out, the rate that she was being paid is well below what would be in the Legal Services Act, which would apply to her. Obviously, the super wasn't paid, pay-as-you-go tax was not withheld. There's issues around payroll tax. There's issues around all the NES entitlements, leave, personal carers leave, annual leave, obviously underpayment of wages. I don't know what sort of hours she was working, if there was issues of overtime, because she's covered by the jurisdiction of the Fair Work Act. That means she's also covered by a modern award, and she's entitled to all the NES entitlements. So this is a massive risk, and it isn't just limited to unfair dismissal. Anyway, that decision was appealed. Dijital Group appealed it and said, look, there was two grounds for the appeal. One was in terms of she was an independent contractor, not an employee. This is what the employer argued. And they secondly argued that they could rely on the exemption under the Fair Work Act. And that exemption, which I talked about just before when I opened up, it says, it's a section 35(3) of the Fair Work Act, which says if the employee is engaged outside of Australia, so I emphasise the term engaged outside of Australia, and the employee's engagement is to perform duties outside of Australia, then the Australian employer is not captured. So while the Australian employer might be a national system employer under the Fair Work Act, the employee will not be considered an Australian employee, and therefore the Fair Work Act won't apply. So in this appeal, Dijital Group said, firstly, she was an independent contractor. Now, if that was accepted, it would mean all of those risks I just talked about, other than potentially super, all those risks would fall away in terms of the modern award, unfair dismissal, or the NES entitlements. And the second part of the argument was, well, even if she was an employee, Dijital Group could provide on that exemption I just talked about, being the engagement was outside Australia and she was engaged to perform her duties wholly outside Australia. So in terms of the first point about independent contractor, now another point I'll make is this decision was decided before the new changes to the Fair Work Act, which have actually made it even harder for an employer to describe someone as an independent contractor, because there are now deeming provisions in the Fair Work Act which will deem someone who you think is an independent contractor actually be an employee. So this decision came down before that, but nonetheless it was still found on appeal that Ms. Pascu was actually still an employee. Anyway, Dijital Group said, well, she was an independent contractor because she was the owner of the equipment she used, so she had the computer she used at home. She had the capacity to control the order of the files she dealt with each day. She was able to control, to some extent, the hours of her work. Now, on that point, she was required to work Australian business hours, okay? She used specific skills and experience to provide the services, so this was credit assistance. She was paid an hourly rate more than the rate generally paid to paralegals in the Philippines. She was never subject to control by Dijital Group in relation to her file management. She had initiated contact with Dijital Group seeking to enter into the business to arrange this independent contractor arrangement. She had never worked in Australia or held a work visa which enabled her to perform any work in Australia. And the independent contractor agreement used the term independent contractor 52 times and the term employee only 5 times. I can tell you that last point means nothing. It doesn't matter what you say in the contract. It's actually the substance of that contract. So the two issues on appeal was whether Ms. Pascu was engaged as an employee or an independent contractor by the Australian company, and the fact that Ms. Pascu physically performed work outside Australia. So in terms of the independent contractor employee argument, the full bench that was on appeal said no, she was an independent contractor. The two critical issues that the appeal looked at was the extent to which the Australian employer had the right to control how, when, and where she performed work, and the extent to which Ms. Pascu could be seen to be working in the Australian entity's business as distinct from in her own business as distinct from the employer's business. And in both cases, the full bench said that it was clear that she didn't have much control at all over how she performed work. And it was clear she was really embedded in this Australian business, this micro firm business. Like she had the telephone number, the email address sign off when she introduced herself either via correspondence or on the phone. She introduced herself as being blah, blah from micro firm. So it was clearly she was embedded in that business. And really what the full bench said that was Dijital Group incorrectly relied on the label of the legal relationship rather than the legal rights and obligations it created. So they went down on that. So the second point where they could have got off on was whether she was a national system employee. So that's really whether she was actually engaged to perform work in Australia, or whether Dijital Group could rely on that exemption I talked about. So basically, the Commission was satisfied that Dijital Group was an Australian employer, and that Ms. Pascu was an Australian-based employee under Section 35. So the question was whether the exclusion could apply, that being whether Ms. Pascu was an employee engaged outside Australia to perform duties outside Australia. So there's no issue that she was engaged. The engagement is to perform duties wholly outside Australia. So there's two limbs to the test. One is she engaged outside Australia, and is the engagement to perform duties outside Australia? So clearly the engagement was to perform duties outside Australia because all of the duties that Ms. Pascu performed were in the Philippines. The question is, how do you interpret is engaged outside of Australia? That has been a very difficult term to come to terms with, and basically in considering whether an employee engaged by an Australian employer but performing work out of Australia was covered by the Fair Work Act, the Commission really needed to look at the first part of that test. The concept of being engaged outside of Australia was referring to the location of where the contract was formed, not where the work's performed. So it's not where the work's being performed, it's where the contract was formed. Where the contract of employment was signed in a different country and sent by email to Australia, the formation of the contract is in Australia. The contract was only formed once communication of acceptance by email was received. So as you can see, and I'll talk about it in a couple of other cases, even though the contract was sent to her in the Philippines, contract was signed by Ms. Pascu in the Philippines, but then she sent that back to the Australian company. And the way the law looks at that first limb of the test is the contract actually fully formed once that had been communicated, the acceptance had been communicated back in Australia. So for that reason, the Australian entity could not rely on the exception, and it was found that she was an Australian employee. Now, I'll compare that to, there was a National Australia Bank case. I'll just quickly go through that because it gives you a bit of a distinction. In that case, Mr. Singh filed an application for unfair dismissal against his employer, NAB Global Innovation Centre India Pte Limited, which was a wholly owned subsidiary of the National Australia Bank. To determine whether the exception applied, the Commission considered the two-limb test. Firstly, the engagement outside limb, which required identification of the location and the formation of the contract, which we just talked about. And secondly, the performance limb, which dealt with the issue of whether the duties were performed in or outside of Australia. In regards to this case, the Commission found that the contract of employment was formed and executed in India. Therefore, Mr. Singh was engaged outside Australia. So even though he argued that he was performing all his work for the benefit of NAB Australia, that didn't matter because clearly the performance test was satisfied. He performed all his work in India, but the other issue was he signed his contract outside of Australia and the engagement was created outside of Australia. Now, for entities like NAB, that's obviously much easier because they'll have overseas entities set up to do that. It's much easier for a lot of other businesses which don't have overseas entities and are seeking to engage offshore workers, and how do they actually form the contract with it being formed outside of the country and not within Australia. So that's in a sort of nutshell. I know that's been quite fast and it's quite technical, but it might be good if we have a bit of a Q&A, and certainly Peter, if you've got some comments that you'd like to raise, and we can explore this a bit more.
Yeah, Annie, look, I think everyone will agree it is certainly a very complex area of the law. And, it reminds me that the same way that you've got the contractor versus full-time test in Australia, that also applies and has even more complexity when you're involving overseas workers. So,
yeah.
And so from what I'm hearing, which is quite interesting, is can Australian businesses still be liable under the Fair Work Act if the offshore team member has never set foot in Australia?
Absolutely. So that was the case with the Dijital group that we just talked about. Ms. Pascu had never set one foot in Australia. She performed all of her work in the Philippines. She was labelled as an independent contractor, but notwithstanding any of that, the Australian Commission said, no, she's an employee under Australian law and she has all the rights in terms of all the employment rights that an Australian employee would have.
Yeah, wow. And I think this is an area where there's often a lot of, fear, uncertainty and doubt. And, often there's various pieces of information. And I think that's one of the common things that I think many people have thought is the fact that the team member's never been to Australia, never been engaged in Australia, that they're protected in some shape or form. So, definitely a high risk area for a lot of organisations to be thinking about when they're engaging those team members as well. And certainly if there's any questions from any of the audience that you'd like to raise, feel free to pop them in the chat in order to maybe answer some of those misconceptions that you might have. But another question for you, Annie, is what determines when an overseas worker is an employee versus when they're an independent contractor?
Oh, that's a really good question. So the law, so the Australian law will apply. The Australian law is extremely complex, to put it mildly. There's a few little issues. One is now under the Fair Work Act, there is actually a statutory provision. So there's a part in the Fair Work Act that now says if all these things apply, it deems someone who is an independent contractor to actually be an employee. Now, a lot of what's been put in the Fair Work Act is sort of similar to the tests that have been applied. So usually we always have to apply the tests that were set down by the courts. The two main things that are being looked at is how much control the individual worker has over the performance of their work. And now when I say control, it means are they being directed by the employer and managed by the employer in terms of performance? Doesn't mean micromanage, but it means they're being given directions in terms of how they perform and when they perform and what they have to deliver. That's a really important. Now, for a lot of the arrangements I see, particularly with an individual, there's usually is control, and there's usually quite a bit of control. Another part will be whether they have the right to delegate the work to someone else. So we engage Mary Jo over in the Philippines, and if Mary Jo doesn't want to do the work, can she flick it to someone else to do the work? And I often see that's not something that the entity in Australia would like, because they want to keep control over who's actually performing the work, and there's often some confidentiality issues as well. And then the third thing that's often looked at is Mary Jo, the worker in the Philippines, running her own business, or is she really embedded in this business? So the business in Australia has its own branding and own email and everything. So when Mary Jo is jumping on calls or sending emails and actually performing the work, is she doing it as Mary Jo, proprietary limited, her little business, or is she actually doing it as part of this Australian entity? And usually when we're talking about individuals, so it's a bit different when they have their own companies, but I'm talking about an individual that doesn't have a company. When we're dealing with an individual, there's usually a much, much, much higher risk that they're going to fall into the into the employee category and not the independent contractor category. So just because you've got an agreement that says independent contractor agreement and you're not an employee and all of those things, that will mean nothing. Though we really look behind that to see what's actually going on. And those three things that I talked about are very important.
Yeah, wow, that contract really is a veil that can be looked through. And I think, many people have often thought that, simply putting the word independent contractor, as you said, protects them. And it's really the substance of that relationship that is so important for everyone to be aware of. And so for our listeners, Annie, many have different relationships that they might have with existing offshore team members today. So, what should Australian employers do to ensure that their current arrangements are compliant with Australian employment law?
Well, I think they need to establish what the nature of the engagement is with this person. Is the nature of the engagement one of an independent contractor, or is it really that of an employee? And if it's that of an employee, they're really subject to resident tax issues and resident super issues. They really need to be treating that person like they would treat any other of their Australian employees. That means NES, if they're full-time employee or permanent employees, leave entitlements, if they're covered by a modern award, to make sure they're being paid in accordance, at least for all the minimum entitlements under the modern award. If they're entitled to overtime, are they getting overtime? So all of those things. There's also the work health and safety piece as well. So there's really there are some differences, but generally they would want, if they're employing someone as an employee, they really need to be treating them no different to their Australian employees. To mostly, there are some differences, but not many. But in terms of the risks under the Fair Work Act, the risks of underpayment, Like, for example, in the case we just talked about, she was getting a flat $17 an hour, and $18 an hour, sorry, and nothing else. So you can see there's a potential underpayment issue there. She wasn't receiving, leave entitlements and those sorts of things.
Yeah, it sounds to me that for anyone that's already got existing offshore arrangements, they really need to seek that professional advice. So, an organisation like Cooper Grace Ward that specialises in employment law is definitely something that organisations should think about, really just to make sure that, this is a very nuanced area. And I think, business owners often have a lot to worry about. And this is just one more thing for them to, really be across. And I think that's where that independent expertise of, Annie and her team can really help organisations to make sure that they're protected. And so, Annie, you sort of touched a little bit on some of the risks that are there, but what's the consequence? So you spoke about the particular case that there was a fine of $10,000 there that was handed out as a result of the findings. But what are the consequences of getting it wrong?
So, the consequence of getting it wrong can be quite significant. Obviously, one issue is this was an unfair dismissal. So the claim here was that they were unfairly dismissed. Those sorts of claims are fairly mild because there's a cap of maximum of 26 weeks salary, and usually the sorts of payments people get are anywhere between 4 to 6 weeks, sometimes more, but I mean, that's on the average. But the bigger risk, in my view, is the underpayment claims, the failure to comply with the modern award, failure to pay national employment standards, entitlements, so, your leave and things like that, failure to pay overtime if that's applicable, failure to pay at least the minimum rate of pay. Those are bigger risks because all of those provisions in the Fair Work Act attract what's called a civil penalty. So, if, for example, the employee brings a claim, if it's not resolved and they decide to bring proceedings, or even worse, if the Ombudsman becomes involved and decides to do an audit, for example. Now, usually there's lots of opportunities to rectify, but if that isn't, I mean, the worst case scenario is there is a prosecution in the court, and not only is the underpayment required to be repaid, but there's interest, but there's also the risk of significant civil penalties. Now, they're usually in the worst case scenarios, but that's where it can lead. So unfair dismissal is really, in the scheme of things, quite a minor risk. The other risk, because obviously the advantage of offshore working is different sort of rates, and as we can see in this case scenario, and we know Australian rates are much higher. So you can just imagine if you've decided to set up a unit maybe of offshore workers and discover that actually that's an employment relationship, and wow, they were covered by this award, and oh no, we haven't paid that. You can see things building up. So that's really where the big risk lies. And on top of that, there's obviously the super risk as well. As we know, if super's not paid, then there can be significant penalties from the ATO in terms of super.
Yeah, wow. Look, the length and breadth of the risk there that employers have by having offshore team members when they're hiring directly, it really is quite vast there. And, they're really opening and exposing themselves to, a risk that is quite significant. And I think, the reason that people are often offshoring in the first place is the cost arbitrage. And it's
Yes.
often seen going directly to somebody. They might initially engage them on like a freelance platform like Fiverr or Upwork, and then hire that person then to be dedicated and direct. And what seems like a good deal seems like it comes with incredible risk. And I think bringing in an organisation like Digital Team to be able to take care of all of the compliance and employment related risk definitely seems like it's something that organisations should be thinking about, because that small cost differential not only removes any of that risk, but it's also the little things that organisations like Digital Team do, some supplying equipment, to providing training, to running amazing events to keep teams engaged, all the way through to little things like the birthday cake there. So I think one of the key things for any organisation to think about is it worth the risk to go direct when potentially that back pay could go back many years, but also open exposure to then ATO risks around superannuation and the directors' penalties that are associated with that. So, Annie, really insightful there what you've provided about understanding what the implications of this recent Fair Work case are. And we'll just open up the floor to any questions that anyone may have before we look to wrap up today's session.
And while we're looking at the question, I might add that these cases are becoming more and more frequent. So the word is out in the sort of offshoring scene that there are rights available, and that's sort of getting around as well, because we're seeing more and more of these cases now where offshore workers are bringing claims under the Fair Work Act, where 10, 15 years ago we were hardly seeing anything. And that's obviously reflective of these arrangements growing so much.
Yes, Annie, one question that's just come through is if someone has a team member offshore that's hired directly, what should they be doing this afternoon to protect themselves? So it sounds like, there's immediate need there. What are the next steps that somebody should be undertaking?
Well, they should be establishing whether the person has been employed as an employee or a contractor. If they've been engaged as an employee, it's likely, but not impossible, but likely they will be an Australian national system employee, unless the engagement occurred outside of Australia, which often isn't the case because the contract's going to be coming back to the Australian entity. So then you need to be understanding, well, if they're an Australian employee, are we paying them correctly? Would be the first step, either under a modern award, or if there is no award, at least under the national minimum standard rate. Are we supposed to be paying super? Are we supposed to be withholding tax, etc.? So really understanding what's the nature of the relationship. Has the engagement been that of an independent contractor? If it is, are they really an independent contractor? If it's not and it is an employment relationship, are they going to be covered by the Australian laws? Probably, yeah. Well, in a lot of cases, yes, given that tricky thing about engagement outside of Australia and when the contract's coming back into Australia, that is the employment contract. So those are the things I'll be immediately looking at.
Fantastic. And Annie, look, really appreciate the insight of really being able to distill what is a very, very complex area of employment law into really a bite-sized chunk that everyone can understand. And I think, for anyone that's got any employment-related issues, whether they're offshore, whether they're related to updating contracts to make sure that they're compliant with NES and that other standards that constantly change out there, I'd highly recommend that you contact the team at Cooper Grace Ward and have that specialist team be able to provide you that protection across not only your Australian team members, but also offshore team members as well. So thank you very much for your time, Annie.
Thank you very much, Peter, and thanks everyone. See you next time.